ladies and gentlemen, you're about to find out how racial identity was defined and stolen in many cases by the ancestors of the Caucasoid race. Racial Integrity Laws, 1924 through 1930. Racial integrity laws were passed by the General Assembly to protect whiteness against what many Virginians perceived to be the negative effects of race mixing. They included the Racial Integrity Act of 1924, which prohibited interracial marriage and defined as white a person who has no trace whatsoever of any blood other than Caucasian, and Public Assemblage Act of 1926, which required all public meeting spaces to be strictly segregated, and a third act passed in the 1930s that defined as Black a person who has even a trace of African American ancestry. This way of defining whiteness as a kind of purity in bloodline became known as the one-drop rule. These laws arrived at a time when pseudoscience of white superiority called eugenics gained support by groups like the Anglo-Saxon Clubs of America, which argued that the mixing of whites, African Americans, and Virginia Indians could cause great societal harm, despite the fact that the races had been intermixed since European settlement. So, since white people came to this country, that's when race mixing began. That's what they're saying. From his position as state registrar of vital statistics, Walter A. Plecker micromanaged the racial classification of Virginians, often worrying that Blacks were attempting to pass as white. Virginian Indians were particularly incensed by the laws, and by Plecker in particular, because the state seemed intent, listen to this, y'all, on removing any legal recognition of Indian identity in favor of the broader category colored. Who did they call colored in this country? Okay, let's move on. After one failed try, lawmakers largely achieved this goal in 1930, drawing negative reaction from the Black press. The Racial Integrity Act remained on the books until 1967, when the U.S. Supreme Court in Loving v. Virginia found its prohibition of interracial marriage to be unconstitutional. In 2001, the General Assembly denounced the act and eugenics as racist. Yeah, but look at how long it took them to denounce it, ladies and gentlemen. 2001? These people are insane. White Virginians had long been concerned with careful defining the legal rights of different races. What you were doing was trying to make sure you kept yourself at the top. Interracial relationships, and thus mixed race children, were common from the earliest settlement period among whites, free Blacks, and Indians, and especially under slavery. Listen to this. When female slaves were regularly subjected to forced relations with white men, despite the close social connection between races. The legal system created separate racial categories in order to establish status and rights. In 1662, the General Assembly articulated the key concept that a child followed the condition of the mother, no matter the status of the father. So in other words, they could create more slaves. The white man could create more slaves with the black woman and define these children all as black. That's what this was really for. This was to protect him from any responsibility to those biracial children. That's why they wrote this into law. Both providing incentive for slaveholders to increase their slave property by impregnating enslaved women, and also contributing to the concept that whiteness would be defined by the absence of blackness. In 1705, the General Assembly articulated specific racial groups and restricted the rights of African Americans, Indians, and mulattoes, defining the latter as anyone who was the child of an Indian or the child, grandchild, or great-grandchild of an African American. So at that point, at 1705, it didn't matter if a white woman birthed a child that was fathered by a black man, the child was now defined as African American. And that was to protect the white woman because they were having a bunch of mixed race children back then too, ladies and gentlemen. That's why they had to change the laws. You know what was happening at the time by the fact that they had to change laws around and reword things. In 1785, that definition was simplified. A mulatto was anyone with 1/4 or more Negro blood. In 1860, the definition stayed the same. 6 years later, however, mulatto was replaced by the word colored. And Indians were now defined as, listen to this, Indian, in order for you to be an Indian, you were defined as not colored or having 1/4 or more Indian blood. That's when they stole the identity of Indian. All right, let's move on. That definition remained the same in 1887 and 1910. But in the latter year, the Assembly broadened its definition of a colored person to someone with 1/16 or more Negro blood. Such definitions were a function of white supremacy, or a way of organizing society in which whites used the law, social customs, and sometimes violence to maintain power over other racial groups. Isn't that what they do with their cops today? Or them always with the threat, oh, I gotta go buy a bunch of guns and they're selling out the gun shops. Now you know where that came from. They've been doing this all throughout history, ladies and gentlemen. In time, some whites came to believe that their power was threatened by, listen to this, immigration. Now, what's happening today? Muslim ban, DACA, rescinding DACA. So you can see nothing has changed with these people. Nothing has changed. They're the same today as they were centuries ago. Nothing has changed. They were threatened by immigration then, they're threatened by immigration now. And especially racial mixing. Although non-marital relationships were commonplace Interracial marriages that legally recognize any such relationship had been prohibited in Virginia since 1691 and declared absolutely void since 1849. Still, whites, blacks, and Indians in Virginia sometimes married. According to federal census reports between 1890 and 1910, the number of mixed-race Virginians, mulattoes, as they were referred to in the census, increased from 122,441 to 222,910. However, that number dropped drastically in 1920 to 164,171. Some white people wondered whether this change, along with a longer gradual decline in the number of Black Virginians, was the result of African Americans passing as white. Actually, no. During the Reconstruction, that was another time when Blacks were moving throughout the country. If they had any sense, they would have figured that one out, but apparently they didn't have sense. Helping to fuel these concerns was the Eugenics Movement, which was based on the idea that, and of course they slapped the human label on themselves, and they're actually hybrids, that humans can be selectively bred in similar ways to plants and animals. And remember, the breeding farms, the slave breeding farms were in Virginia. Virginia actually had the largest ones in the country. Using large statistical studies, eugenics purported to scientifically demonstrate that mental illness and criminal tendencies were inherited and should specifically limit in the human population. So they're saying that, anybody that was dark had mental illness and criminal tendencies, although they have the most violent history. Okay, moving on. They also argued that African Americans, Indians, poor people, criminals, prostitutes, and alcoholics all suffered from inferior genes. No, actually, Black people have dominant genes, thank you very much. For reasons many eugenics maintained, it was critically important that whites not mix with supposedly inferior races. We're not. We can wipe you out just from one sex session. So I mean, really, no. In part, in order to accomplish this separation of races, the state found it necessary to keep track of who was white, Black, and Indian from 1853 until 1896. Virginia required that all births and marriages be recorded, and that the race of all parties be noted. The place was resumed. The practice was resumed in 1912 after the General Assembly established, and this is where the vital statistics come from, ladies and gentlemen, the Bureau of Vital Statistics under the State Board of Health. So the vital statistics was created out of racism. Okay, they needed to keep track of those Negroes and Indians in the country. So that's really why it was created. Local registers were required to report all births, deaths, and beginning in 1918, marriages to the state register. Yeah, because they wanted to know what race you were, who was interracially marrying or making an attempt to do so. This all was about race. And it was these devils that set this entire thing up to be about that, along with people's racial identity. The new state register, Walter A. Plecker, was a white supremacist and a believer in eugenics, who recognized that his new position could be used to prevent the mixing of races. In 1922, Plecker and Ernest S. Cox and the noted pianist and composer John Powell founded in Richmond the Anglo-Saxon Club of America. That's just a eugenics group, by the way, ladies and gentlemen. According to Powell, the group was dedicated to finding the fundamental and final solution of our racial problems in general. And we know who the racial problem is, most especially the Negro problem. Jesus, these people. If you stayed in a cave, you wouldn't have no Negro problem. Race mixing was a priority concern for these men, just like it is today. Articles by Cox and Powell, published in the Richmond Times-Dispatch on July 22nd, 1923, wondered, is white America to become a Negroid country? Is white America to become a Negroid nation? Oh my God. You know, these are the same people that come and tell us we talk about race all the time. They talk about it, wrote laws about it, and wrote reports about it in books and papers and catalogs and all kinds of things. You don't have no room to talk about no one. On August 4th, Plecker released a statement arguing that his position at the Bureau of Vital Statistics is perhaps the greatest force in the state today combating this condition, because it was his power especially to apply the state's racial definition and so decide who could marry one another. Indeed, Plecker admitted to applying a standard beyond the law when identifying people as African American, whereas the General Assembly had defined colored in 1910 as someone with 1/16 or more Negro blood. Plecker defined it as someone with even a trace of Negro blood on either side, so either the mother or father side. This included nearly all Virginian Indians, according to Plecker, because they had thoroughly interbred with African Americans. Moving on. In 1923, the Anglo-Saxon clubs suggested that a new racial integrity bill be enacted, and the group's motivation, in part, was for the law to catch up with how government officials such as Plecker were already behaving with regard to race. The Racial Integrity Act. The Racial Integrity Act was introduced in the General Assembly as Senate Bill number 219 on February 1st, 1924, and House Bill number 311 on February 15th. In its original form, it required that all Virginians fill out a certificate of racial composition to be approved by the Bureau of Vital Statistics. The certificate would be necessary in order to marry in Virginia, and it would be against the law for a white person to marry anyone but a white person. Although interracial marriage had been banned previously in Virginia, this was the first time that marriage between whites and Asians or other people who were legally neither color or white was prohibited. So even if they were married to an Asian person, that marriage was null and void at that point. Another law passed in 1924 defined a colored person as having 1/16 or more Negro blood. And an Indian was having the same proportion of Indian blood. Okay, so an Indian or a black person were both defined as colored, ladies and gentlemen. The Racial Integrity Act went a step further and attempted a first for Virginia, defining a white person. According to the proposed law, to be white, a person must have no trace whatsoever of any other than Caucasian blood. So they couldn't have anything but Caucasian blood. In other words, the standard already being applied by Walter Plecker. However, people who had less than 1/64th part Indian or no African American heritage would be considered white. This exception catered to those elite Virginians who counted themselves as descendants of Pocahontas and John Rolfe. The historian J. Douglas Smith has noted that the African American press remained relatively quiet about the bill, aimed at those mixed race persons who were no longer clearly identifiable as Black. He argued the the proposed statute did not affect directly the vast majority of Black Virginians who had no desire to pass as white. In fact, in a letter to the Richmond News Leader published on February 23rd, 1924, Gordon Blaine Hancock, a professor at Virginia Union University, wrote, "The Negro is not demanding acclamation." In other words, Black people weren't demanding to be white. We weren't saying anything about these laws that they were writing all over the damn place. All right, so let me just go down. So, Black people really didn't say much. I don't think they really cared, what these people put down on paper. You can tell who was having the issue about race. It's pretty obvious. All whites were, not all whites were pleased with the bill either. Senator Holmes Willis of Roanoke called it an insult to the white people of the state, largely because of its requirement that all Virginians register their race. The Senate eventually amended the bill to make such certificates voluntary for all people born before June 14th, 1912, or when the Bureau of Vital Statistics was established. The new version also allowed white people to have up to 1/16th Indian blood. Finally, the burden of proof regarding the veracity of a person's racial certificate was placed not on the state, but on the individual. The Senate passed the modified bill on February 27th by a vote of 23-4. After voting down the earlier version on February 21st, the House followed the Senate's lead, approving the bill on March 8th by a vote of 72-9. Governor E. Lee Trinkle signed the Racial Integrity Act into law on March 20th. In September 1924, James Connor and Dorothy Johns applied for a marriage license in Rockbridge County. The clerk, A.T. Shields, determined that Connor was white, but that John, in addition to be part white, was also part Indian and African American, citing the Racial Integrity Act. He refused to issue a license, and John immediately sued in the Circuit Court of Rockbridge County, testifying before Judge Henry W. Holt. Walter Plecker presented birth records showing John's colored ancestry in Amherst County, and Salas Coleman, a resident of Amherst County, provided anecdotal corroboration. John's attorney argued that those family members referred to as colored were in fact Indian. You see how what they did just caused mass confusion? Not only did they classify racism, they also turned around and caused confusion among it. Wow. Judge Holt refused to issue the license, finding sufficient evidence that John was at least part African American. He did, however, note the ways in which the case suggested problems with the Racial Integrity Act. For one, there was no consistent definition of Indian in Virginia law, making it difficult to use historical record to determine ancestry. For another, he foresaw problems related to the burden of proof laid out by the law. Would it always be possible for a legally white person to satisfactorily prove that he or she had no non-white ancestry? He suspected not. Another case raised similar questions. A few weeks later, the same clerk in Rockbridge County refused a marriage certificate to Robert Painter and Athea Searles for exactly the same reason he had refused one to Connor and Johns. Searles, he claimed, was part white, part African American, and part Virginia Indian. Searles also sued. On November 14th, 1924, Plecker testified once more before Judge Holt and was joined, this time by John Powell. Salas Coleman was asked to present evidence again as well, but declined out of fear of community retribution. This time, Holt ruled in favor of Searles, while suggesting that he generally supported the intent of the Racial Integrity Act. He again raised concerns about the burden of proof the law placed on individuals, and because testimony in the Searles case had demonstrated no strain presented in the application of any blood other than white, except Indian, and there is not enough of that to come within the statute. He had no choice but to grant a license. Powell was outraged. If this decision is to stand, any Negroid in the state can go before a court and say my ancestry are recorded as colored. But that does not mean Negro. They were Indians. But who did they call colored in this country? The black people that you're looking at. And they even had signs up. Whites, no coloreds. He may then be declared white and marry a white woman. He predicted that the state would soon be bursting with Indians. In addition, in an editorial published on November 20th, 1924, the Richmond Times-Dispatch urged the state to appeal the Sorrells decision, but the attorneys general decided against it. Pleckard, meanwhile, decided to target Virginia Indians, seeing them as obstacles to a pure white race. He made efforts to prove that all Indians were actually, listen, African Americans. Let me read that again. He made efforts to prove that all Indians were actually African Americans and attempted unsuccessfully to persuade the director of federal census to not recognize Indians in Virginia. All Indians were actually African American. George Major Cook, chief of Pamunkey Indians, wrote a strongly worded defense of the Virginia tribes to the Richmond News Leader on July 8th, 1925. And in a letter dated December 1st, Governor Trickle admonished Pleckard to be conservative and reasonable and not to create any ill feeling if it can be avoided between the Indians and the state government. Revising the Racial Integrity Act. On January 14th, 1926, Robert O. Norris, Jr. of Lancaster County introduced in the House of Delegates a revision of the Racial Integrity Act and redefined a white person in Virginia as someone whose blood is entirely white, having no known demonstrable or discernible admixture of the blood of another race. In other words, it did away with the so-called Pocahontas exception and made it impossible for people like Dorothy John and Atia Sorrells to argue successfully that they were white. It also responded to Judge Holt's concern by making it easier for courts to deal with uncertainties inherited in 19th century records. Still, the concern that had led the Pocahontas exception in the first place had not gone away. Some estimated that as many as 20,000 white Virginians possessed small amounts of Indian blood, which would, under this revision, make them legally colored. In response to these fears, on February 12th, the House amended Norris' proposed revision, allowing the definition of white person to include 1/8 or less Indian blood, as opposed to 1/16 in the 1924 Act, as long as the person has no other demonstrable admixture of the blood of any non-white race. On March 5th, 1926, the House passed the amended revision of the Racial Integrity Act by a vote of 52-18. But 1 week later, the Senate voted 20-9 to indefinitely postpone the consideration. Public Assemblage Act. While the General Assembly considered the Revised Racial Integrity Act another controversial rage, it began the Grace Copeland, a childhood friend of John Powell, attended a concert at Hampton Normal and Agricultural Institute, later Hampton University, a private school founded in 1868 to train Black teachers. Copeland, who arrived late, was forced to sit next to African Americans, a fact that angered her husband, Walter C. Copeland, the editor of the Newport News Daily Press. In an editorial published on March 15, 1925, he accused Hampton of practicing racial equality between whites and Negro races. This proves they never wanted equality, and they still don't want it now. Hampton's principal, James E. Gregg, responded cautiously, while the predominant Black intellectual W.E.B. Du Bois defended the school more vigorously in Crisis, the magazine of the National Association for the Advancement of Colored People, the NAACP, an editorial in the Black-owned Norfolk Journal and Guide published on July 25, 1925, asked why Hampton, which employed white teachers and administrators such as Gregg, was being singled out for criticism, especially when many institutions in Richmond had did the same. It is because at Hampton Negroes are treated as human beings, and at other places they are treated as inferior human beings. The Anglo-Saxon Club, however, sided with Copeland and demanded a new law. So when they don't get their way, they demand another racist law. Boy, I tell you, some things never change. Rescinding DACA. You don't like the law? Change the law or do away with it. On January 20, 1926, George Alvin Massenburg of Elizabeth City County in Hampton introduced House Bill number 30, which required the separation of white and colored persons at public halls, theaters, opera houses, motion picture shows, and places of public entertainment and assemblages. The bill was opposed by the Norfolk Virginian Pilot and its editor, Louis I. Jaffe, as well as the Richmond News Leader and the Richmond Chamber of Commerce. Baptist missionary groups worried that the law would force them to provide separate seatings at events for visiting Chinese and Japanese students. A concern mocked by J.A. Rogers, a mixed-race journalist from the North. One would have thought they, the foreign students, were citizens and Negroes, the aliens, he wrote in the Norfolk Journal and Guide. On February 5th, the House passed Massenburg Bill 63 to 3, and the Senate followed suit on March 9th by a vote of 30 to 5. Harry F. Byrd, now governor, felt pressure to exercise his veto, but he let the Public Assemblage Act become law on March 22nd without his signature. Privately, he called the legislation extremely regrettable, but he did not publicly oppose it. Hampton Board of Trustee, meanwhile, under the leadership of Chief Justice William Howard Taft, declined to either protest publicly or sue. Rather than comply with the law, however, the school stopped opening to the public events such as the concert attended by Grace Copeland. During the same session of the General Assembly, bills to criminalize interracial sex and to seek support from Congress for colonizing all of the states African American failed to pass. In a letter to Byrd dated October 17th, 1927, Copeland suggests how far, perhaps, she and her allies in the Anglo-Saxon Club had come from strictly scientific claims about the mixing of genes. She wrote that it was impossible to reason with a Negro. That the only way to keep him in his place was to keep him under fear. Isn't that what they do today? Reasoning means going along with white supremacy. That's what reasoning means to them, ladies and gentlemen. Final acts. In 1928, the General Assembly attempted to fix a problem with its racial definition. According to the law, a colored person was someone with 1/16 or more Negro blood, while a white person had no trace of non-white blood. So, how should the law define someone who was part African American but less than 1/16? Rather than create a new category, House Bill Number 2, introduced by James H. Price of Richmond on January 18th, redefined color. The term now would be applicable to anyone having any ascertainable degree of Negro blood or who is descended on the part of the father or mother from Negro ancestors without reference to or limit of the time or number of generations removed. This concept became popular, known as the one-drop rule. Virginia Indians vigorously opposed the bill, fearing that such language would lead to their legally identified as colored, and by extension to their legal and cultural identity being erased. I will tie a stone around my neck and jump in the James River rather than being classed as a Negro, cook of the Potawatomi Indians, said at a Senate hearing on February 3rd. Yeah, because they saw how Negroes were enslaved and treated and lynched and burned in this country. So, of course, they would have a fear of being labeled as Negro. So that just go to show you, why would you try to label somebody as Negro if they didn't look Negro? See, just food for thought. The black press in Virginia took issue with Cook's statement for their perceived insult to African Americans. In the Virginia Planet, John Mitchell Jr. responded sarcastically, certain it is that Negro joined with him in his effort to maintain the racial integrity of his tribe, and they do not want any of its mongrel members thrown over to their side of the contention. So, again, it was okay for black people to stand and fight with them, but at the end of the day, you got rejected. Isn't that what happens today? Moving on. While the House passed the Price bill by a vote of 68-9 on January 30th, the Senate rejected it on February 13th, 26-13. 2 years later, though, the issue arose again. The Richmond Times-Dispatch had reported that white schools in Essex and King and Queen counties were being forced to educate young people who fit neither the legal definition of white nor colored. A new bill A new bill was introduced with language similar to Price, defining as colored any person in whom there is assertable any Negro blood. It was again opposed by Virginia Indians. In a hearing on February 1st, Cook told the assembly, "You have taken our land, taken our forests, taken our fishing grounds, and now, with one stroke of the pen, you are trying to take our very name." The Senate responded by amending the bill to provide that members of Indian tribes living on reservations allotted them by the Commonwealth of Virginia having 1/4 or more Indian blood and less than 1/16 of Negro blood shall be deemed tribal Indians so long as they are domicilable, on said reservations. Because they did not live on reservations, Indians in Amherst and Rockbridge counties henceforth would be classified as colored according to the new law. So listen to this. As long as they stayed contained on the reservations, they got the title of tribal Indians. But if those Indians did not want to live on the reservations, they got slapped as colored. All right. The amend Senate bill passed on February 13th, 1930. By a vote of 36-0, the House passed it in 1 week later, 81-3. Governor John Garland Pollard signed it into law on March 4th. See, a lot of them didn't want to live on the reservations because the reservations were in bad shape. And it was very hard to live on the reservation. That's why a large amount of the Indians lived outside of the reservation because of the conditions. Legacy. Race relations in Virginia were harmed for more than a generation by the Racial Integrity Act and the Public Assemblages Act, which prevented whites and non-whites from marrying or gathering together in public places. Although in the 1920s, the leaders of the Campaign for Racial Integrity warned repeatedly that Virginia faced a bleak future, indeed, the utter collapse of its civilization, unless the most extreme measures were taken. The historian Richard B. Sherman has written, somehow the state managed to survive. Still, Walter Plecker remained the state registrar until 1946, despite admitting privately in 1940 that there was no test to determine the race of an individual. And the law he helped write remained in effect until 1967, when the U.S. Supreme Court in Loving versus Virginia ruled that the prohibition of interracial marriages was unconstitutional. For Virginia Indians, the wait for justice lasted longer. Beginning in the 1980s, the state recognized a number of Virginia Indian tribes, only then helping to migrate the legal and cultural damage done by the various laws, racial classification. In 1997, Governor George Allen simplified the process for Virginia Indians of correcting their birth certificate. In 2001, the General Assembly denounced the Racial Integrity Act of 1924 for its use as respectable scientific veneer to cover the activity of those who held blatant racist views. And it shows the timeline here. I will leave the link to this article in the description box, but you can see how they defined race and then they muddied the waters and caused confusion. So they were the ones to define it, and they were the ones to cause all the confusion in the country, ladies and gentlemen. Are we surprised? No, because all they do is cause confusion today. Please tell me what you think. Leave your comment and subscribe. And if you can donate to my channel, please do. And those of you that have donated over the last few days, I deeply appreciate it very much. Peace, family.